Good morning, I'm Gary DeWaal, and this is Bridging the Week for February 6th through 10th, and today is February 13, 2017. A renowned retail foreign exchange dealer agreed to shut its doors as a result of enforcement actions taken by the Commodity Futures Trading Commission and the National Futures Association, while the Securities and Exchange Commission's Office of Compliance Inspections and Examinations provided a top 5 list of issues it has seen during investment advisor inspections. Although some of OCIE's identified topics are likely of interest only to investment advisors, most of its observations regarding compliance procedures are relevant to all SEC and CFTC registrants and supporting practitioners. It was a light week for developments in the U.S. financial services industry, while most eyes were focused on other developments occurring in Washington, D.C. However, a few matters are worth review, so let's get started. Forex Capital Markets LLC, the renowned retail foreign exchange dealer, and 2 of its principals, Drew Niv and William Adud, agreed to terminate their business to settle charges by the Commodity Futures Trading Commission that, from April 2010 through 2014, the firm misled customers when an interest in a market maker that often traded opposite FXCM's customers, while advising them that the firm executed transactions solely on an agency basis. The defendants consented to withdraw from registration with the CFTC and to pay a fine of $7 million. Contemporaneously, FXCM, the same 2 principals, and Ornit Niv, currently the Chief Executive Officer of FXCM and sister of Drew Niv, resolved charges brought by the National Futures Association based on the same basic facts by also agreeing to withdraw as members of NFA. In 2011, both the CFTC and the NFA imposed fines against FXCM of $8 million combined for disadvantaging its customers in trade executions. In 2014, the UK Financial Conduct Authority fined Forex Capital Markets Ltd and FXCM Securities Ltd 4 million Great British pounds, or approximately $6.7 million for effectively the same offense. The Securities and Exchange Commission's Office of Compliance Inspections and Examinations published a risk alert that sets forth the 5 topics that it most often identified in deficiency letters it issued to registered investment advisors. Chief among these deficiencies were the failure of investment advisors to have and follow written policies and procedures reasonably designed to ensure its compliance with law. Not a good thing. Too often registrants adopt cookie-cutter policy and procedure manuals that are overly generic and mostly parrot regulatory requirements without meaningfully reflecting how the firm will actually comply with such obligations. Moreover, policy and procedures, once adopted, sometimes become company heirlooms that mostly gather dust on a shelf and are rarely consulted, let alone updated. Policy and procedures that are adopted to comply with regulatory requirements must be reasonably designed to address the relevant subject matter, should reflect the firm's actual practices, and should be continually updated to reflect current practices and personnel. Moreover, before implementation and periodically afterwards, policy and procedures should be assessed holistically, ideally by non-drafters, to evaluate their completeness and effectiveness and to recommend enhancements for improvement. The CFTC's Division of Market Oversight issued a no-action letter extending for 6 months the time persons eligible for certain disaggregation relief under the Commission's new aggregation requirements must file a required notice with it. Originally, notices had to be filed by February 14th. Under this relief, they must now be filed by August 14th. Previously, and under amendments to the CFTC's aggregation standards adopted during December 2016, a trader of futures and related options positions in any of the products where the CFTC has directly established position limits must aggregate positions it holds directly with positions in accounts in which it controls the trading or has a 10% or more ownership interest, unless there is an exemption from aggregation available. 2 notable exemptions are the independent account controller exemption and the owned entity exemption. I include details on these exemptions, including how they work, and a discussion of exchange requirements to obtain similar exemptions in the article version of Bridging the Week on the website. Check it out. And finally, the CFTC authored 4 virtually identical no-action letters that excused the Cayman Islands-based trustee from registration as a commodity pool operator where, in connection with its acting as trustee of a Cayman Island-based commodity pool, it delegated all its investment management authority to a non-affiliated registered CPO. Previously, the division granted broad no-action relief to non-natural persons who might otherwise be required to register with the CFTC as CPOs if they delegated all their investment management authority to another non-natural person CPO that owned it or was under common control, among other conditions. In my view, this relief is practical and appreciated. However, it is premised on a too broad view by the CFTC of who is a CPO and must be registered in the first place. I expressed my thoughts on the article version of Bridging the Week on the website. Check these out, too. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal, and I won't see you for 2 weeks, as next Monday is President's Day, and I am taking the day off. As a result, have a great 2 weeks, and until January 27th, ciao!